Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cintron. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cintron.
Hi, everybody, and welcome to the Mock Podcast. This is one of my favorite ones of the year. We undergo a 4 or 5 month program here at Lois Law Firm to really test the litigation skills of our entire litigation teams, attorneys and paralegals. And so I'll introduce first last year's mock trial champion for paralegals, Cara Malanowski. Welcome back to the show.
Yeah, it's nice to be back on this side of the table. So welcome all. Congrats on making it this far. I'm excited to kind of wrap this up and see who takes the championship this year.
So Cara was on, you were on the other side, and maybe
it was this side of the
table.
Oh,
it was this side. Okay, so we recorded from that side. Great. What were you feeling when you were a finalist heading into the podcast round?
Definitely a little bit of nerves, but also confidence for making it that far, especially considering the pool of people that I was up against. So I'm sure you're all feeling kind of the same thing. Also just excitement to wrap up another year of mock trial.
Were your hands cold?
They were probably definitely a little bit clammy, but
okay. Yeah. Well, let's welcome our finalists. Right now we have Wallace, Priyanki, Rana, and Josh Roman. Welcome to the show, guys.
Hi.
Thank you.
So we started this thing off, right, with submission of a case theory, right? So you guys gave me a case theory of what has happened over the last 4 or 5 months, and then I submitted it anonymously to these two next to me, and we essentially came up with a point system to actually introduce what the prompt was. So without further ado, I'm going to say that on the morning of April 21st, 2023, an event acknowledging Dr. O'Donnell's new position as chief of surgery was ambushed by the recently terminated Dr. Dunch in the doctor's lounge of University Hospital. Dr. Dunch presented to the event brandishing a gun and was apprehended by a security guard. Dr. Dunch then alleged he sustained a work-related injury while being restrained by the security guard. The claim has been disallowed by Judge Declan Gorley, who determined that Dr. Dunch committed fraud and is not entitled to benefits. There's video evidence to support the fraud finding, and further, Dr. Dunch was in the commission of a crime during the alleged injury. Dr. Dunch's injury was idiopathic and therefore not compensable. So I feel like that kind of frames it for our listeners here. So congratulations to one of you finalists who submitted that. And let's go to probably my favorite portion of the entire program, the trivia round. As you guys know, from listening to last year's podcast, questions are worth either 1 point, 3 points, or 5 points. There are only 6 questions available for you in the bank. 2 are worth 1, 2 are worth 3, 2 are worth 5. So one of you is going to pick a question, and that leaves, the remaining 5 questions to be picked by everyone else, right? And it's going to go so on and so forth. So Josh, you were in 3rd place heading into this round. You can pick first. What question would you like Cara to read off for you?
3 point.
A 3-point question. All right.
Okay. What were the incidents that led to Dr. Dunch's termination?
He prescribed medication to people who didn't need it. He removed a spleen or a kidney instead of a spleen. He was receiving back-end deals from the pharmaceutical company. He abused prescription drugs and overprescribed drugs.
All right, I think I am going to award Josh half credit for that one. We definitely had some of them. For steal of the remaining 1.5 points, do you guys want to guess what the other incidents were that led to his termination? That'd be Ryan and Pri. Okay, so you guys both wrote it down, right? Mm-hmm. So just one of you, what do you got?
He also left a sponge.
That's what I had too. So
Okay, so you both got a sponge. Okay, so no one got the amputation of the wrong leg.
Oh.
So I'll give you guys each half a point, right? So 1.5, and then half for you guys. All right. So a 3-point question is off the board. We've got 2 1-point questions, 1 3, and 2 5s. Pri, you're in second heading into the podcast round. So where are we going from there?
I'll also take a 3-point.
Okay, a 3-point question.
What are the names and occupations of the witnesses interviewed in the investigation report who did not testify?
Okay, so who did not testify? We have, sorry, can I give 1 second? We have nurse Allison Cole. She was the nurse supervisor. And then we have Dr. Joseph Malchione, who was the president, who also didn't testify. Then we had Nicholas Fortino, who was the pharmaceuticals rep. I believe Dr. O'Donnell didn't testify either, who's the chief of surgery. And Cara testified, who was the chief compliance officer, and then Dr. Dunch, who is obviously the claimant. So, yeah.
That's correct. Correct. So our thanks to Allison Cole, Nick Fortino, and Joe Malchione for helping us out, even though they didn't get to testify. I think they probably wanted to.
I don't know.
Okay. All right. So Pri's on the board for 3 points. Ryan, you're up. We have 2 1-point questions or 2 5-point questions.
Let's go with the 5.
All right. 5-point question.
Okay. What were all 4 of the alternate mechanisms of injury that were in the medical reports?
This one's a tough one for sure. It's every medical report.
Had something else?
Alternate mechanism of injury. I would say, in addition to being shot, Dr. O'Donnell had his shoulder pulled. Christopher Major also injured his shoulder, breaking up the altercation. Dr. Dunch stated that he injured his toes in the shooting as well. Dr. Chris Major also said that he probably hurt both of his shoulders, and then Dr. O'Donnell had a spleen injury.
Unfortunately, that is incorrect. Yeah. Incorrect. Would either of you guys want an opportunity to steal?
Can you restate the question?
What were all 4 of the alternate mechanisms of injury that were in the medical reports?
Okay. Can I try? If I try, then I lose the 5 points,
If you
right?
try it and you don't get it right, you do lose the points as well.
But what if I get half right?
Well, why don't we just see? I can't.
The risk is yours to take.
Yeah.
You know what? It's fine.
All right.
Okay.
So the alternate mechanisms were us
Okay.
being. Oh, you're going to try it.
No, I'm going to try.
Okay. I thought you were saying you were not going to try.
No. You know what?
Okay.
I'll risk it. So one of the reports said that there was a physical altercation / assault. The other, there was either scaffolding or something related to that. There was PTSD due to something, and then the person noted in one of the reports tripped over something. Sorry, I know I'm saying tripped over a lot,
Yeah.
but
I
hold on.
mean, there weren't.
Wait, was it a
those
ladder?
weren't the 4.
There was. She got one of them. I would even say 2.
Okay.
I would say she got 2 of the 4.
Okay, you got 2 of the
assaulted by a
4.
coworker, and then it was large sheetrock.
Oh, okay. See,
All right, so
yeah.
we'll give you 2.5 points. All right.
Okay.
4 mechanisms were assaulted by a coworker with a knife, large sheetrock falling on a foot to cause a backwards fall, lost footing and hit a head on a control panel for sprinkler alarms, and walking when falling to twist an ankle. All right. Now we're going back to you, Josh. We have 2 1-point questions and 1 5-point question.
Do 1.
I'm going for a 1.
All right. What are the names of the 3 potential claimants from this accident?
Dr. Dunch, Dr. O'Donnell, and the security guard, Chris Major.
That's correct. That is correct. Sometimes I'm looking at these and I'm like, the 1s are so easy and the 5s are so hard. But, that's how it goes, I guess. All right, that's correct. We're now back to you, Pri. We have 1 1-point and 1 5-point.
Do I want to risk it? Or do I want to do the 1? Is like the Jeopardy music playing? Is that what's going on while I
in my
decide?
head, for sure. Don't get cold hands.
Okay, fine. How many points do I have right now? 7 something?
I don't know.
No, 5.
We're
5
all
and a
going
half.
along, right? I'm relying on my judges here. I just bring the personality.
All right, I'll be safe and go with the 1. Sorry.
Go with a 1.
Yeah.
All right. Who could be a potential defendant in a third-party claim?
Potential defendant, I believe it would be Dr. O'Donnell, or since he was assaulted, or the security guard officer Major, since he tried to intervene and he was also allegedly injured. So either of those 2.
All right, I'll accept that. Accept that as an answer. 1 point for you, Pri.
Our
And
answer
that
on here
leaves
was
a
major
5
security.
point for Mr.
Okay, so we're good.
Wallace. 5-point question for Mr.
Okay,
Wallace. Yeah.
let's try this again.
Well, you have no choice.
Yeah.
Other than socks/shoes, name 3 items of clothing that Dr. Dunch was wearing in the surveillance video.
Oh, he was holding a golf club and also tools to fix his car. He was wearing golf shorts in the golf course video, and he was wearing jean shorts when he was fixing his car. He was wearing a tank top when he was fixing a car, and he was wearing a very nice golf polo in the golf video.
That's correct. I, of course, listed jean shorts as jorts, but
Yes, same.
I'm going to give you credit for that. Good job. All right, so we finished the trivia round. Bonus question, of course.
Okay.
All right, this is for everybody. And you're going to get 10 points if you get it exactly correct, or 5 points if you're the closest without going over. Price is Right rules. Okay?
Okay.
How many participants finished the mock trial program this year? How many participants finished the mock trial program this year? All right. Do we have numbers? All right, we got a number from Ryan, we got a number from Josh,
57.
and we got a number from Pri. Correct answer is 32. 32
Damn,
people
that's crazy.
finished the mock trial program this year. So that will go 5 points to Ryan for being closest. All right. Now that we finished the trivia round, we're going into the oral argument phase of the podcast. What we did was we gave you guys 4 different issues to argue, and you can take either side. The other 2 people will then get to be the rebuttal as a tag team against the person who's choosing the issue, right? So you guys don't know which issues you're going to pick. I have a little surprise for you. You can pick the issue you want. So again, we'll start with you, Josh. You're in 3rd place. What issue would you like to pick to argue on appeal, and what position are you taking?
That he was not an employee.
Okay, so you're going to take the position that Dr. Dunch was not an employee of the hospital at the time of the incident. Is that what you're saying?
I'm actually going to take the position that he wasn't an
That
employee.
he was an employee. Okay, so you are going to say you're the claimant's attorney, and now Ryan and Pri, you are now representing the hospital, saying that he's not the employee. Go ahead.
There were no termination papers provided to Dr. Dunch when he was allegedly fired, and his ID scanned in when he presented to the event, which means it wasn't deactivated.
That's true. That is true. We learned that at trial, right? So, what do you guys say to that?
I mean, he was clearly terminated a few weeks prior to the alleged accident. Even he even conceded during testimony that hey, by the way, like I had a meeting like a couple weeks ago and I was fired, or like not fired, but like terminated. And when he attended the event for Dr. O'Donnell, he said like he wanted to, before he even attended, he said that he only attended because he wanted to roughen up Dr. O'Donnell. So like clearly like, he did it out of spite.
The night before, he also said, I want to fight for my job back. And it's impossible to fight for a job back if you have the job.
It's interesting. Any rebuttal to the rebuttal?
Well, the hospital had sent an email out to all coworkers saying that he was fired, which seems like an HR issue. And if they went to lengths to advise everyone that he was fired, but they never even handed him termination papers.
So whose like fault is that? I guess like, like if Dr. Dunch believes he's fired, but maybe the hospital doesn't go through with termination protocol, like what would you guys say like is someone who should bear the burden of proving that that issue?
I would say that he hadn't been served termination papers yet. He'd only been terminated a few weeks earlier, and given the complicated situation that he found himself in and that the hospital had to deal with in terms of patients, that we don't know if we know there was no termination paper yet, but we don't know if that was forthcoming and what needed to be done in the background in order to deal with all of his malpractice issues.
That's true, but wouldn't that actually help Josh's point, right? If he wasn't terminated yet, or like the hospital.
Well, I shouldn't say he wasn't terminated yet. He hadn't been given the full paperwork as of yet. He was terminated, and it was very clear to him too that he was terminated. But in order to write everything down on the official paperwork, other than an HR email, which articulated that he was terminated, it might have taken a longer time, given the issues.
I mean, piggybacking off of what Ryan said, the HR did request Dr. Dunch to like return all materials, especially like all employee provided materials to the hospital, but he refused to do so, clearly. We even have witness testimony indicating same. So clearly, like, it shouldn't be that. I mean, again, like, I don't think that like he should have been under the impression that he was not terminated when he clearly was, and there's like witnesses indicating that he was too. So
you know what's great about that is like when we came up with this scenario, that was definitely not something that we would think was going to be a triable issue, and the fact that the assault happened and we're just like, oh wait, is he an employee? I think it was just so random that came about, and it really was shown by people just diving into the materials and trying to find things, which is exactly what this program is for. So, all right, great job, guys. We're now going to move to you, Pri. You were second coming into today. So Josh has taken employee relationship off the board. What issue would you like to argue, and what side would you like to take?
Okay. I believe I will be doing fraud, because I love fraud, and I also, find a lot of fraud in my regular cases. So I'll be doing fraud.
Gonna take that he committed fraud, or that he
committed fraud? So I'll be on the carrier's
you'll
side.
You'll be the hospital, which means Josh and Ryan, you are now the claimant. We're going to be arguing that he did not commit fraud. Mm-hmm. All right, let's go.
Okay, so clearly the claimant, the claim was disallowed. The judge noted that in his reserved decision. Clearly the claimant violated section 114A by misinterpreting material fact in contradiction to the medical evidence and the testimony that he himself gave. So based on that, he did commit fraud. There's also video surveillance and social media which indicate him performing physical activity. And so again, if people say that social media should not be counted, I mean, it clearly should be counted, considering social media pages are under the public sphere, and there is no requirement in disclosure or producing information that is self-published by the claimant himself in advance of the testimony. There's substantial evidence indicating that he did violate it. The video was again served on all parties. He's seen even playing golf or like going under his car. I don't think there should be like any issue as to why, like, you know, sorry.
Oh, it's okay. So there's a clear, at least, issue for us to really discuss. So Ryan or Josh, what would you argue that in terms of the opposite side, that he didn't commit fraud?
I would argue that Dr. Dunge blew his toes off on his right foot during this accident, which supports the fact that he was legitimately injured from this event.
Okay, but he did that to himself, if you think about it. He brought in the gun, which was clearly out of personal vendetta, and he basically attacked someone who was trying to present himself in front of someone. So it's also non-compensable, and it's non-compensable under workers' compensation when it's clearly a civil suit, since he assaulted someone. So that wouldn't really,
A fight can be compensable under New Jersey law if the fight has to do with issues regarding job duties.
Okay, but this is
Well,
under
let's
New
let me
York
hear from
workers'
Ryan.
not New Jersey.
Let me hear from
And
Ryan.
if
I
it
would
wasn't-
argue
Sorry.
two separate things. What I argue first is even if he was able to do the activities that we saw on the surveillance video, that he was a doctor, more specifically a surgeon, and therefore those injuries prevented him from conducting his job, but maybe not other activities, especially given that a surgeon requires a really finite amount of control over your body in very sensitive situations.
Okay.
Secondly, I would argue that in the date of loss, Dr. Dunch may not necessarily have been in completely of sound mind due to the fact that he was, as Nicholas Fortino Pharmaceuticals testified, taking AB 105, which is medicine only for animals, not human beings, which was negligently provided to him, and his side effects including profuse sweating, shakes, and most importantly, increased temper.
Okay, so you mean to tell me that he's taking medication which were not prescribed to him, which he himself abused. So you're...
Medication provided by the hospital.
No, the pharmaceutical rep is not represented by the hospital. So again, during the Mr. Fortino's testimony, he said that the claimant himself was asking for more medications. Therefore, he himself did that to him. He himself did that to himself by abusing medication.
What
So
about
that
the video
wouldn't really-
itself? Like the video itself, did you guys feel that it was properly authenticated based on the testimony at trial?
I do not feel that way. No.
Okay. Okay,
Had you
I
in.
mean-
Is there a lie behind that, or you have a situation where we took it was taken from his social media, right? And then there was also something where the employer, I guess, found him working on the car itself, wearing the jorts, of course. What is that video good enough to pass as evidence for a judge to even review?
Yeah, I mean, absolutely. It's within my it's right there in front of me. If something is in front of me, I can do whatever I want. Let's say I want to take a picture of the tree. For example, that HR person could have been taking a picture of the tree or the car that that Dr. Dunch was under. Maybe it was a really pretty car. Maybe, the HR personnel saw that hey, wow, this is a vintage car. Let me take a picture of it. So clearly, if anything's, in eyewitness level, then they can do whatever they want.
I disagree. I disagree for the reason I stated before, that his ability to do his activities doesn't mean he could do his job, which again requires a really precise level of attention and control of your body. And in addition, in those videos, we don't know the context of what that day was. We don't know what medication he may have been on, in the sense that he may have been given medication for his pain that really made him able to do daily activities of living, but not still enough to do his job, or potentially could affect his mental state in order to return to work. And the only way he could return to work properly is once he can do those things without medication.
But why would he return to work when he was terminated? And also, if he's under the car, shouldn't, like, and he allegedly injured his right leg and his right toe, like blew off his toes, wouldn't going under the car require the use of your right leg and your toes just to like bend down to put pressure on it?
Well,
or like in general, or even if those sites were injured, wouldn't you be using your arm, which the claimant is saying that he injured?
It's not that he can't use it at all, it's that he can't use it to the degree that he would need to for work purposes.
But he was terminated, and his license is under investigation, and so based on that, like, why would he go back to work?
It's being argued whether or not he was actually terminated.
Yeah, but for the time being, he's on probation, so he clearly...
As a surgeon, he's aware of what activities he can perform with certain types of injuries. He deals with that all day. He knows what people can.
Okay, but wasn't he just caught abusing medication, and he was just caught with leaving multiple items in a claimant and amputating the wrong site? So...
Yeah, but the evidence is prejudicial because we don't know the circumstances of what was occurring on the days of those activities. We don't know if he was taking we don't know if on that day at those moments he was taking medication prescribed to him, whether or not it wasn't prescribed to him, what previous medical treatment he'd undergone before or just after. We don't know any of the context, therefore it's prejudicial, leading to a conclusion without all the facts.
Hey, Cara, what are you doing this weekend? It's getting real spicy here. Let's just for purposes of time, we'll call that issue done and now go to Ryan. So we have 2 issues left on the board. Which issue would you like to take and which side?
I would like to do issue 2. If Dr. Dunch was an employee, whether or not the incident was an accident in the course and scope of his employment, and I would like to take the side of the defense of the employer.
Okay, so now we're assuming that he is an employee at the time of the incident, and you're going to say that this accident still was not in the course and scope of employment.
Yes.
Okay, so you are going to be hospital, and then Josh and Pri, you will take the claimant side.
Okay. Don't you have to go first?
Yes. Okay. So I would argue for the hospital that he was suspended at the time of the data loss. He was not invited to the event on that day. He stated that he only knew about it because of social media. The president of the hospital, Joseph Melchioni, testified that there was no reason for him to be there that day. Cara Malanowski also testified to the same effect. And also because his medical license was under probation, he would have been barred from actually doing anything related to the practice of medicine. So there was no reason for him to have been at the hospital that day, even if he was technically still an employee at that time.
I mean, he clearly was still an employee at the time, and the accident that arose at the work event was an open invite, and everyone was required to attend. He still had his employee key card, which, by the way, should have been taken if he was allegedly terminated, which he was not. So
this accident also occurred at approximately 10:05 in the morning, which is normal working hours, and it was in the doctor's lounge, which is, I'm assuming, a room specifically for people who are hired as doctors at this hospital, and he was technically still an employee. There's no official documents to prove otherwise.
Well, the issue isn't whether or not he was employed. The issue was this in the scope of his employment, and it was not. He was not invited or asked to be at the hospital, as testified by Joseph Melchioni and Cara Malanowski.
Were there invites sent out?
Do you have a list? Or like, is it... Yeah. Do you have a list of people who were invited?
Well, presumably, given the testimony that he wasn't invited, there was individuals invited to the event by the hospital specifically, and he was not.
Okay.
And he was not asked to be there on that day for any reason.
I mean, he was not terminated. He's still an employee, and like the accident clearly did happen at the employment. I don't know if you've looked at
the accident happened on the premises of the employer, but that doesn't mean he was working in the scope of his employment, especially because it was due to personal animus between him and Dr. O'Donnell, as he spoke about the night before with Chris Major about his intense dislike, and as testified by Nurse Cole, that there were repeated altercations between them in the past.
Okay, but is the testimony on record? Because I don't know if you remember at the trial, Nurse Cole did not testify. So if you're using that as a basis to like back whatever you're saying, then like where is the actual, like what are you referring to? Like where, like it's not on the record.
Also, an event commemorating a promotion is regarding job duties, which makes it in the course and scope of an employment, and it's to the employer's benefit for employees to be there because it's a celebration about the new chief of surgery.
This was my favorite one.
It wasn't an employment event for him. It was for
going.
Dr. O'Donnell, and it wasn't done under amicable circumstances. It was done to do his suspension of his medical license and the replacement necessary for chief of surgery.
Okay, so let me ask
That
you this.
doesn't seem like an event that he would be invited to.
I don't think anyone was technically invited. There's no list.
Yeah, it's an open invite, so like anyone can come and go. Even the security guard wasn't paying attention. Like he was also involved.
Whether or not the security guard was properly conducting his duties is irrelevant to whether or not someone.
But isn't he employed by the hospital then? Like, shouldn't you guys like, make sure that if like the security guard like should be monitoring who should come in and who should not? If like that wasn't done properly, then like how can you say that it wasn't within like the scope of the employment?
It wasn't in the scope of his employment because, again, as Joseph Melchione said, there was invites to the event.
And is that testimony on the record?
That testimony was given to us in witness interviews.
Okay, but is that testimony on the record? If it's not on the record, then like we can't really use it.
President Melchione also stated that he wanted to keep this accident hush-hush, so I think he's more concerned with his own personal reasons. He's not going to be, his credibility is in question at this point.
That still doesn't change the fact that he wasn't invited to be there.
Okay, but how do you know who was invited?
We know because, as was testified by Cara Malanowski as well, he was not there for any work reason. He wasn't asked to be there in any way, nor does it make sense, given that his medical license was suspended, that he would be there, especially given it was a promotion event for his replacement.
So then why wasn't his key card taken away if like he wasn't an employee? And like he shouldn't have been
Well, the
there?
issue isn't whether or not he was an employee. The issue is whether or not he was there in the scope of his employment.
Which he was.
He was still an employee under probation. That's why they didn't take away his key card. Clearly, there are issues related to his medical license that still need to be worked out. Again, we've already adjudicated the issue of whether or not he's an employee. The issue is, it was this event, the promotional event, that he was not asked to be there, which is on the record, and under which was promoting his replacement in the scope of his employment, and it was not. There was no reason for him as a suspended employee under probation of the hospital for him to be at that event on that day, except due to his stated dislike of Dr. Addison O'Donnell, and he also said that he described him as an animal.
I guess I should also say, with an uncommon last name, that my partner Joseph Melchione did not do anything wrong. He's playing a role. Keeping it hush hush was just part of the act. But I do like that comment, Josh. I think we'll close there, right? So you guys each have had the chance to argue a point that you chose, and then had to field like a tag team. How did that feel compare to like the trial and the hearing? Like, would you guys say that this was like harder? Definitely. Why so?
I don't know. It was fine. I don't know about these two, but I came prepared with both sides. So there were a few out of the blue.
Well, Josh, you mentioned that this one was a little bit more difficult. What was difficult about it compared to some of the other prompts that we had?
I think the pace in this is just quicker, since
That's true.
at trial there's multiple people making different points, so you can attack each one, which here's just like a series of thoughts.
Yeah, you're kind of also on your own, right? No teams anymore. And we can all feel like when it's like becoming dead air, and it's just like, then I'm going to start saying something to push. Any thoughts from you, Ryan?
Yeah, it's just diffusion of responsibility. I feel like not a team behind you, not a team against you either, just more focused on you and them. So definitely a little more difficult for that reason.
We felt a lot of between you and them.
Yeah. Well, that last one was super intense. I was just like, should I just like wheel myself out of the room here,
thanks
guys?
so much.
Well, I thought everybody did great. Also want to commend you guys for the work and the performances you guys had for the last 4 or 5 months. I think it's just a way to really show that creativity and advocacy is built on just prep, right? Like when you work on something and you can give yourself the opportunity to put yourself in a position to say any one thing that puts the other side at risk of having to defend against you, it really demonstrates the individuality that you guys can have and really contribute not only to something like this, but to the cases that you work on. I think that, you know, some claimant attorney people that I know that listen to this podcast, if they see this and they try to ask you to join their firm, you should probably say no, okay? Just stay with us. We're going to be just fine. So for Josh Roman, Priyanki Rana, Ryan Wallace, my co-chair, Cara Malanowski, my name is Christian Cintron. We'll be right back with the attorneys. Hi, everybody, and we're back. This is the attorney segment of the mock trial finals, and we have 3 new competitors this year. I don't know how they're going to live up to our paralegal performance, but they're going to try. I was actually saying at the end of that last segment that if our competitors listen to this, or maybe I hope that they don't, because they might just start poaching our paralegals for how good they're doing. But first, I'd like to welcome back to the show last year's mock trial champion, Connor Wetherington. Yes, you just gave a wave. We're not on video, but welcome back to the show. How does it feel to be on this side of the table today?
You know, it feels really good. You know, the past 3 times I've competed, I was on the other side of the table sitting in those seats. But it feels good to have someone else's fate in my hands.
There it is. That's the Connor Wetherington we all know and love. So just to, I guess, thank our listeners for still listening to us at this point, I'm going to read a different case theory. It's going to be the same fact pattern that you guys may have heard in the paralegal portion. But let's see if you guys think this is better. I'm actually interested to see if the loyal listeners that email me about the podcast every so often will tell me if they like the attorney prompt better than the paralegal one. So we're going to go with this person. The judge's decision to disallow the claim and find the claimant fraudulent must be upheld in its entirety, as it does not contain any error of law or fact. The claimant, a former disgruntled employee of the hospital, trespassed hospital premises after learning of his termination and assaulted a current employee of the hospital. Therefore, there is no compensable work-related accident, since the claimant's termination makes evident that no employee-employer relationship exists. Moreover, properly authenticated video surveillance was produced for all parties to review, showcasing the claimant working considerably on his car and enjoying himself at a driving range. The surveillance produced evidence of no disability and solidifies the judge's determination that the claimant lacks any minutia of credibility. All right.
It's a good word there, minutia.
Yeah? That was definitely your favorite one. Okay, so I think our listeners have it, and now we move on to my favorite portion of the entire year. This is trivia. We're going to do a little bit differently. I know you guys listened to last year's podcast, or even if you didn't, doesn't really matter because we got new rules. There are 6 total questions in the bank. All right, 2 questions are worth 1 point, 2 questions are worth 3, 2 questions are worth 5. Paralegals have already taken questions from the bank, so those questions that they were given are not provided to you, which means that I guess the questions that Cara left for you guys could be harder or easier. I don't know. So we're going to start with the person in 3rd place. That would be you, Tomer. And you can pick 1, 3, or 5.
Gotcha. At random, I choose.
You can choose up 1 point, a 3 point, and 5
Gotcha.
point. If you get it right, you get that amount of points. If you get it wrong, you lose that amount of points. If you lose that amount of points, your competitors can also steal.
Let's go for a nice and easy 2-pointer.
Well, since there are no 2
sorry.
point
We
questions,
have
I don't even know whether to subtract.
Get a deduction for that?
We're definitely not deleting that from the podcast
Yeah,
as
that's
well.
good. Okay.
I think
Fair.
we got to go back and relist the point system. It's 1, 3, or 5.
Already the paralegals are ahead.
Yes. All right. So you know what? We'll go for 3. I'll go back.
Go
on
for
that.
3.
Yeah.
All right. Take it away, Connor.
Name the 3 non-finalist attorneys / paralegals who won a prompt.
Okay.
Tomer's like, who other than myself didn't, or who won?
So 3 for both paras.
There are
And
3 total attorneys and paralegals that won a prompt that are not recording a podcast. Who are they?
okay. So there's Diana, there's Jess, and there's Karen.
That is correct.
Ding, ding, ding.
Diana Goodwin won the hearing prompt. Karen Olarte won the hearing prompt as well. And Jess won the trial prompt. Good job. All right, so 3 points for you, Tomer.
Thank you.
We'll go to Alexis Cintron next. You're in second place. You can pick a 1, 3, or 5.
I'm going to stay at a 3 for right now.
Ooh, okay. The last 3-point question on the board, Connor.
All right. Alexa, this question is
Hold
for
on.
you.
And I want to say this is a timed question. So you have 15 seconds to answer this one.
Did Tomer have 15 seconds?
This
to
one's a
answer?
little easier.
Okay.
What are the names of the 4 providers who were deposed, and what was their area of specialty?
So, Dr. Carafin was pain. Wait. How many seconds do I have?
7.
Carafin was a
6,
pain management
5,
doctor. Dr. Rodin was
3,
a regular MD. Cunningham was a psychiatrist, and
Sorry.
Dr.
Can I
Purcell.
steal that?
You guys can steal, but you also have 15 seconds starting now.
Dr. Fursel is an anesthesiologist. Dr. Carafin is a pain management doctor. Nurse practitioner Cunningham is a psych mental health nurse practitioner, and Dr. Roden is an orthopedist.
All right, that is correct. So, Alexa, you'll get 1.5 points, and Cory will take the other 1.5. All right, Cory. You're in first place heading in, Mr. Benavides. 1 point or a 5-point question?
Let's go 5.
Oh, let's go.
If you could repitch Dr. O'Donnell's case to the hospital, what would you recommend?
As if I were representing Dr. O'Donnell?
As if you were representing the hospital. You're pitching to the
hospital.
hospital. So remember what was pitched.
What I would do is claim that it's a non-compensable accident based on the fact that the assault occurred because of an animosity between the 2 parties involved in the assault that had nothing to do with their professional or employment life within the hospital. It exists outside the hospital, which I believe they were on a hockey team together and had some issues there. There's been mention of them having arguments with each other outside of the hospital, which has no professional implication and therefore not within the course or scope of their employment. And the mere fact that the assault occurred on the hospital premises is not in and of itself compensable.
Is there a means to add on to that, or as far as a steal? I'm not sure how that would work.
Let's see how many points I get first.
Yeah, I'm actually, because the thing is like if we award the points for that, then you would know that like that would be what we were looking for. So if I say that, then I'm more interested actually if either of you two want to add or differentiate. But if you try and you don't have what we were looking for, then you would also lose points as part of the game.
Right.
So,
Well, I think if I were to pitch it to the hospital, what I would focus more so on is the lack of employer-employee relationship here at issue. I think, I'm going to strike that actually,
well, you did talk.
It's too late.
You did talk.
Yeah.
So,
Yeah.
I hate to be a stickler.
Yeah. No one to shoot, I guess.
yeah, this one's a tough one. This is definitely a CSON special because there's no like true right answer. But if you think about where the fact pattern led, right? You have the hospital introducing Dr. O'Donnell as their new chief of surgery, and he is a valuable employee to this hospital. And what the pitch really should have been is you should accept this claim because Dr. O'Donnell's a
That's not the
valuable
lowest way.
employee. While it may be not compensable, you may actually consider the PR aspect of keeping your employees happy if they're valuable to you.
Hoisted by my own petard on this one. I think I used that pitch in my pitch, the PR aspect.
Well, the question was if you could repitch.
I already did that
And
one,
you
so I did
you
a
actually
different one.
won. That's actually you actually won that prompt, Cory, the pitch prompt. And I remember that because it was just a very, very impressive demonstration of marketing. So not to say that pitching that was wrong. I'm really glad that Cara left that for us here because
Brutal.
that is not necessarily like a yes or no. I think that's just like a helpful discussion for everybody.
It was a
I helped Cory with that pitch, don't forget.
Oh, right. You guys are on the same team. Okay. Yes, you're right. You guys are on the same team. You won best team. Cory won best attorney in that. Okay.
So is that minus 2.5?
I don't know. What do you think, Connor? Because like obviously that's not like a black and white. It's a little gray. What do you want to do since you enjoy deciding people's fate?
I think I'm gonna have to give -2 to each.
-2
because
to each.
We wanted to accept it. That was the answer.
Yeah.
That's
Okay.
what we were looking for, and they went the other direction.
All right. All's fair in love and war and podcasts.
Wow. All right. It's going to get that serious. Let's go.
All right.
That was a 5-pointer.
That was a 5-pointer. So Connor could have been harsher. So,
I
Appreciate
could have
that.
gone -5 for both of you. You
Totally
both chimed
understand.
in. Tomer, especially you.
Yeah, I agree with that. But, I'm happy that you're so forgiving. So
Tomer especially.
Just kidding, everyone.
All right. We're back to you, Tomer. You're in third place. We have 2 1-point questions and 1 5-point question.
I'm going to go with just playing it safe with that 1 point.
Playing it safe. Third place. That's interesting move.
Yeah.
Okay.
I'm going to get them elsewhere.
I'll get him elsewhere. Okay.
How did the carrier witness obtain each of the videos?
If I remember correctly, she was the CCO.
Using words to break the
I
silence.
hope you remember correctly because it's worth a point.
That's correct. Yeah. So if I remember correctly, and my memory's, I think, decent on this one, Cara was filming, or maybe not Cara, but was filming personally. The employer witness was filming personally
That
Dr.
is
Dunch.
incorrect.
No?
That is incorrect.
Bum, bum, bum. Yeah. Would anyone like to steal? I saw
Can I
Alexa.
repeat the question before?
Sure, I'll repeat the question. But we'll do, I guess, a buzzer type system or raise your hand really quickly. For who wants to steal, I'll let them, whoever goes first. So the question is, how did the carrier obtain each of the videos?
You also don't have to steal.
I'm going to pass.
I'm going to pass.
All right.
So the correct answer is social media, because the golf one was on Facebook.
And the second part is actually Cara retrieved it from another employee's iPhone. That was the testimony at trial.
Right. Memory did not serve me well on that one.
Hey, humility is a thing too.
My transcript got lost in the mail.
Talk to someone about that.
All right. We'll now go to you, Alexa. No 15-second requirement for you here.
Thank you. So nice.
A 1 or a 5.
I'll go 1.
Okay.
I see what you guys are doing.
Even Cory for the 5s. All right.
Alexa, what was the order of the prompts?
Order of the prompts was, first prompt was the witness meeting and client pitch. The second prompt was the initial hearing with the judge. The third prompt were depositions of the treating doctors, and the final prompt was the trial.
Ding, ding, ding.
That is correct. You get extra points for putting the witness prep in there because No, I just had pitch, but not you don't actually get extra points. But I just want to say to you,
misleading. That was so misleading. I was like, oh, so okay,
That's what we call brownie points.
fine.
yeah, brownie points are good. Okay, Cory, you got a 5-point question here. It's not it's black and white, so
Oh, great.
so it's not as gray as the last one.
Thankfully.
So, Cory, your 5-point question is: what are the first names of all the mock trial judges that graded at least one prompt?
The first names?
The first names of all
First
the
names.
judges that graded at least one prompt.
Connor, Christian, Joseph, Christopher, Cara.
Got 5.
How many there yet? Where how many?
I'm not going to say how many there are, but you have 5 so far.
Do we have a time limit on this? I mean, it's been going on for a
Why
bit.
isn't there 15? He has to list names.
Yeah,
This
5
is where we
names.
put the music
I
drop.
think, I
for
think
the,
we should just cut them off.
Thank you.
All right, 5 seconds.
That's all I got.
Okay.
Can I steal one?
I can still do.
You can steal 2. None of you can steal 3?
Actually, I have it as
Can
4
I?
left.
Can I speak?
Oh, he said 1, 2, 3, 4, 5. Did you say this one? Oh, there are 4. There are 4 left. If anybody can name 4, whoever thinks they can name the most will get to go first.
I can try.
How many do you want to say?
3.
You want to say 3? Do you want to say 4, Tomer?
No, let her get 3 then, if she got 3.
Okay.
Smart.
Jeremy, Addison, Alicia.
That's correct. That is correct. And the last one was Brianna.
Yep.
So 5 points for Alexa, and that nope, the
Wait
trivia
a
round's not
minute.
over. There's one bonus 10-point
What
question.
should we do here with Cory, though?
I did
Oh, no,
answer
he
that
did.
question.
That's true. That's true.
Yeah, he does.
What do you want to do here?
Getting railroaded over here.
He answered more,
He got 4.
but
No, he got 5.
he got 5, but he started.
Right.
I think we should deduct.
I
Don't
think
see
that
how this point
I don't
system
think that
works.
anybody should lose points.
You want to give 5 to both of them?
No, that's crazy.
Maybe not 5. Maybe not 5.
Let's call it 4 and call it a day.
I'm negotiating.
I
think
like-
we should, he got how many? Well,
He got 5.
Yeah,
You
would
you
say
had
this.
3. Alexa.
If my math is correct, which it probably won't be, I would say 3.5 to Cory and 1.5 to Alexa.
Okay. I'll go with that. All right.
Except
There is one final 10-point question. It's for each of you, and it's Price is Right rules, closest to the pin without going over.
do we need to write this down?
No. Well, you can if you want. All right.
For potentially all the marbles. For 10 points. How many participants finished the mock trial program this year?
Finished?
So it's as close as we are. I mean, if we don't have the exact number,
Price is Right rules.
I'm
So
not
if-
familiar. I'll
so-
be honest.
Can't go over.
Do you not have any
If
sick
you
days
if
as a
you
child?
go over the number, you're out.
Gotcha.
So it's everybody who gets the number or below is eligible for 10 points.
All right.
If you get the number exactly, that's 10 points. The closest person, if no one gets the number, will get 5.
Okay. Should we just blurt it out? Should we write it down?
Why don't you write it down so that people don't steal it?
Holy beat.
The paralegal winner was two participants away with their guess.
Dang.
Are we ready?
I think so.
All right, let's flip them. All right,
looks
Tomer
like-
is going to get 5 points. There were 32
It was
participants.
32. I was gonna put 32, but I didn't want to risk it going over. This Price of Right.
Sometimes you have to risk it for the biscuit, my friend.
32 points.
Some risk is okay.
All right. Trivia's over. We're now going to go to oral argument. Paralegals got to choose their issue. You guys, I'm going to choose the issue, and Connor is going to choose the side. Okay? So we'll start with Tomer since you're in third place heading into the podcast. Your issue is When, if at all, was Dr. Dunch no longer an employee of the hospital?
Oh, it's on me now.
I'm going to take points away from Connor.
Good thing I'm not being graded. Tomer, I would like you to be claimant's side.
Claimant side. Okay.
So you'd be arguing that the claimant is an employee,
Right.
but now you have to argue when he is an employee, obviously,
When he is an employee. All right.
or when his employment relationship ended.
Yeah.
That's also the same thing, but just conversely.
Okay. So it is without question that Dr. Dunch maintained his employment status with the hospital beyond the April 21st, 2023 incident, as he maintained his employee access card, which we had heard testimony from multiple witnesses that only employees are given such a card for access to the hospital. He was on premises as he was allowed to be at the time. He had no written confirmation, no actual notice of his termination since that event had occurred. Ultimately, the employer-employee relationship between the hospital and Dr. Dunch continued, and therefore, given the acts that occurred on the premises when Dr. Dunch was assaulted, as I said earlier, they occurred on the premises, and therefore the injury is compensable. Yeah, I'll go with that if that's all right.
All right. What do you guys say?
So, on the defense side, I would say that there was clearly no employee-employee relationship between Dr. Dunch and the hospital. There's a third department case of Ross Lachelle that goes into the factors of assessing the employee-employee relationship. You give consideration to things such as the right to control the claimant's work, the right to discharge, method of payment, furnishing of payment. And in this case, there's evidence that supports that Dr. Dunch was terminated weeks before the date of loss due to multiple issues of malpractice. The hospital no longer controlled Dr. Dunch's work. They didn't pay him anymore. And in this assessment, no one factor is dispositive. So the one fact in the record that Dr. Dunch did not return the key card that the hospital furnished to him should not disturb the board's decision that an employee-employee relationship did not exist between Dr. Dunch and the hospital.
I concur.
All right. Then to that effect, then, doesn't the hospital, you were talking about the right to control, doesn't the hospital control whether he has access to the key card?
That could be an issue that is discussed. However, like I said, the third department case is clear that no one factor in the assessment is dispositive. So I don't think the board level was in their right to afford the credibility to the evidence in the file. And I don't think the board's decision should be disturbed based on one fact that the key card was not returned. There's other factors that go into it.
Right. There's a substantial amount of credible evidence that would establish that fact pattern. I agree.
There's also the argument that he was a disgruntled employee, and if they left on bad terms, it could have been Dr. Dunch who refused to get back the key card. I would give weight to the board's decision.
Okay.
We don't have any indication that Dr. Dunch was told to give back his key card. All we know is that he was off the premises. He maintained his key card, and he was within his right to appear at the presentation for Dr. O'Donnell. There's nothing to suggest that he had any reason to not be there up until
Well, he
then.
wasn't invited. He found out about it through social media. I think he was an uninvited guest who showed up with a gun. I think that's a misrepresentation of the facts.
I think it would make sense that an employee that's no longer employed with the facility.
I'm sorry, an employee that's no longer employed at the facility?
Well, if we're assuming that he
Sounds
was
like a concession
terminated,
that he was terminated.
if we're assuming that he's terminated, he wouldn't have the ability to go through any of the access ports. I think that would be a
Just
pretty
because of the
standard
negligence
policy.
of a security official who was in charge of, you can remotely disengage those ID cards from accessing certain points
Sure.
of.
And that wasn't done.
Correct. That you could point to negligence, sure, but that doesn't establish an employee-employee relationship.
And if I remember correctly, it was not Mr. Major's position to deal with the key cards. That was
Oh
a
no, it could
hospital.
have been another hospital security
It was within.
administrator.
It was within the hospital's domain to control that aspect of it. So, I think the real hinge here is the access that Dr. Dunch had, and it's clear to everyone that he maintained access to the premises. So he was within his scope of his employment when he appeared at the presentation.
Okay. I think that's a satisfactory conclusion to that issue. Alexa, we'll go with you next. You're second. Your issue is whether the video and surveillance materials were properly authenticated. Which side would you like to give her, Connor?
I think knowing what I know, I think Alexa should be on the carrier side for this question.
All right.
So, wait,
You're arguing that the video and the surveillance materials were properly authenticated if you are a defense, right?
right. So, first and foremost, I would say that the surveillance footage was made known to Dr. Dunch and all parties before the testimony of Dr. Dunch was taken. So he was everyone was properly on notice that the surveillance existed. I would also say that our employer witness who testified to the surveillance footage credibly testified. They testified to the chain of custody that was taken with the surveillance, and as it was presented to all parties pursuant to the case law, I think it was properly brought into the record.
If I were to, I from the claimant's perspective, the video surveillance that was provided, while it was provided to the parties timely, there's no indication of when those videos were taken. There's no timestamps on those videos. We heard testimony from Cara Malanowski that she had not actually been the one who took footage of Dr. Dunch. We don't have any understanding of whether the footage was cut, edited, manipulated in some way or another. So despite the timeliness that Ms. Cintron seems to be noting in her summations, I think what we do know is that there is no understanding of the scope of this footage. It was not properly authenticated per the testimony that we heard from Ms. Malanowski.
I agree. I don't know if a chief compliance officer is equipped to make a judgment call on whether or not something was duplicated, manipulated, redated. I agree. The authentication, I think, and the weight that it was given by the judge was entirely too much based on one person's testimony who's not an expert in that field.
Do we know when Dr. Dunch was seen at the golfing range?
I would again, though, just like to add before I get back to that the board or the court gives great deference to the board's determination on witness credibility, and they clearly gave deference to Ms. Malanowski at the trial level. So the board's decision about the authenticity of the surveillance footage should not be disturbed. They believed Dr. Malanowski was credible in testifying to the authentication of the video. And again, the claimant was made aware prior to providing his testimony about the video, and he decided not to correct any of his statements. So again, I would not disturb the board's decision on the credibility of the surveillance footage.
I still think for proper introduction into evidence to at least be considered, you would need an expert in the field of video recording, video editing, to at least look over what's been provided and determine whether or not it's been manipulated in any way, and at least date it.
Did Dr. Dunch ever admit that it wasn't him or allege that it wasn't him on any of those videos?
He testified to it not being him on the video.
He testified to it not being him.
Didn't look like him.
So what would you, as a defense attorney, argue if the claimant is going to allege that that's not me? Because if the judge believes that it's not him, that all the videos and the materials are out, right? So how would you argue that whatever testimony Dr. Dunch is saying is not credible as to whether it's him in the video. That is a toughie, but
I mean,
could be for anyone.
defense could have done a search with motor vehicle. There was an El Camino being worked on with the license plate number -89.
Maybe let's not read that into the recording because
bleep
that
that,
is
John?
my actual car, and I don't want anyone trying to come and find it.
Don't worry. Defense hasn't done that work, so they won't do it. It could have been authenticated to see a man working on another man's car. Usually not the case. He'd be working on his own car, and you could at least identify him, but they didn't even do that.
The key here, right, is that Dr. Dunch has not been credible this entire time, right? So if Dr. Dunch wants to allege that it's not him in the video, all you have to do is point to the inaccuracies in his other non-credible testimony, right? At one point, he was doing a Boston accent. At one point, he was doing a Southern accent. He, is using a neck brace and a cane, and then clearly not in the video. Use the fact that the judge saw Dr. Dunch and saw the videos to explain that, unless there's evidence that Dr. Dunch has a twin brother, then you can really hone in on something else, because when you have to prove a negative, you want to use everything else that you have at your disposal to throw against the wall.
Despite the credibility issues that Dr. Dunch really gave no leeway for, I guess, his counsel, he was not a particularly credible individual. But I don't think that goes to the question as to whether the video was cut, edited. We don't know when it was taken. We don't have timestamps on the video. There's a bunch of questions as to the authenticity regardless of his credibility, I think.
That's true. My explanation was more about the question I posed to defense, right? Mm-hmm. That if the claimant is going to say it's not him on the video, which can happen from time to time because they will try stuff when they know that they're pinned, mm-hmm. right? Usually that's like a sign that their credibility is actually decreasing. All right, great discussion there. Cory, we have one more issue for you, and your issue is which defense is stronger for the hospital, intoxication or intentional injury?
So for the defense, I guess you're not weighing in here, are you?
You can.
I was given two options here.
Yeah, we kind of gave Cory two options there. Do you want to? Do you want to give him one?
I feel like it's only fair if each person is having to be one side or the other.
Sure.
So just for clarity of this judge's sake, could you repeat what the actual question and what Cory needs to answer?
That's how our listeners know this is live. No editing from Mr. Grayson. Which defense is stronger for the hospital, intoxication or intentional injury?
I think, Cory, I would like you to try to answer and figure out if intentional injury is the best.
Just as you say. So, when there's an intentional injury or an assault in the workplace, it can be compensable for either party. The issue here is looking into the details surrounding the assault and determining whether or not it occurred in the course of employment. Now, in New Jersey, if an employee is assaulted by a non-coworker, that employee is pretty much going to have a case no matter what, because they are in that location where they were assaulted or attacked due to their employment. It's a but-for test. So but for their employment, putting them in this position, they would not have been assaulted. That's the logic behind that. So the standard here for Dr. Dunch, bringing outside factors, possibly with his personal animus against another doctor, seems to still be rooted in their competition within the hospital itself. And there are cases that involve assaults or fights between coworkers that have been found compensable that technically happened off premise, although they were in a stairwell one floor above their actual office. So location isn't entirely dispositive. I think it really is looking at where the animus is sorted. In this case, the hospital had just announced Dr. O'Donnell as the chief of surgery, and this is something that stuck in Dr. Dunch's craw, so to speak, and was probably the last straw that he had endured that pushed him to the point of bringing a gun to his place of former employment. Whether or not Dr. O'Donnell engaged in any sort of mutual combat or response, it was a spontaneous reaction to what he experienced as an assault. He saw a man charging after him with a gun. He responded. Whether or not he threw that man to the ground doesn't really matter because he is still not the aggressor. The aggressor is the person approaching with a gun. And by that standard, an aggressor has never been found to have a compensable claim in New Jersey. The intention to injure somebody is what prevents that person, even if they are an employee, obviously, from filing a claim. Now, for Dr. O'Donnell, he is the victim by our standard. He is the person who the aggressor is attacking, and he is responding with a spontaneous reaction to that aggressive behavior. And any injuries that could have occurred to the other party are not important. They're not relevant. The only thing that is relevant is that he was initially attacked. Any injuries stemming therefrom are within the course of his employment. He would not have been in that room but for his employment. And because an aggressor charged in and he reacted, he may seem to have done something. He might be, causing damage to someone else, but it is that spontaneous reaction that prevents him from being categorized as an aggressor and therefore non-compensable. So he is compensable, unfortunately.
All right. What do you guys say about the intoxication defense?
The intoxication defense as the best defense
Yeah.
for the hospital.
Well, what we do know is that Dr. Dunch and Mr. Major had gone out the night before. I think we heard testimony from Mr. Major indicating that they were two good old boys going at a bottle. Is more or less what I remember from the cross-examination that we conducted. But from what I remember, Dr. Dunch and Mr. Major had about 12 drinks the night prior. There's also in the accident report an indication that Dr. Dunch had a few drinks prior to being on the premises on the 21st of April. Now, whether that meets the burden of the high standard, that intoxication was the sole reason that the claimant had, that the intoxication excuses essentially the workplace accident is arguably met here, I think. That's kind of my response to it.
So to add on the intoxication defense, there was a lot of evidence in the file that Dr. Dunch was a drinker and had been intoxicated by alcohol prior to the assault, but there's also, I would think the defense could add in that there was possible medication and drug intoxication as well. There was evidence that there was a lot of pharmaceutical kickback issues with Dr. Dunch. There was witness testimony, I believe, by Mr. Fortunato, who is the pharmaceutical rep at the hospital, that Dr. Dunch was profusely sweating a lot before the assault. He was had anger issues, had shakes, had increased temper, and a lot of that stems from drug abuse. So I would say that we could argue that Dr. Dunch was not only intoxicated by alcohol but also drugs prior to the assault, and there's a good basis for the intoxication defense.
All right. I feel like, and I guess, Connor, you weren't here the last segment. I mean, there was definitely more like tact and reasoning based on legal theory for these arguments. There's no just like, like fighting against each other. So I was kind of hoping like the gloves came off, but you guys actually surprised me very nicely with a lot of like well thought out theory for your conclusions. So that ends the oral argument round. We're going to finish with one surprise, and that is we're going to ask you guys if you can change one thing about the mock trial program, what would it be? Best answer is going to get 5 points, middle answer 3, last answer 1. So while I think, Connor, what are you doing this weekend? Anything fun?
This weekend, I might do some work on that sweet El Camino that was mentioned.
Yeah, there's no chance a license plate was mentioned at all. So I think you're safe.
No license plate. They definitely didn't mention the state it was the license plate's from.
I want to apologize for being thorough.
That was a trivia question. What was Connor wearing during the surveillance video?
How many points was that for Paris?
Yeah,
What was he wearing?
The jorts?
the jorts.
And the trucker hat.
Jorts.
My days.
The paralegal called it jean shorts. And I was like,
You gotta say
It's a
jorts.
missed opportunity.
I don't know.
Yeah, that's accurate, but I think a missed opportunity to put out jorts on the podcast for sure.
They got the people going.
It's okay. I corrected it. I made sure jorts was a word said on the podcast as it's being said now. Jorts.
I am from the South, so it is acceptable attire down there.
All right. Who wants to go first with their one thing they could change about mock trial?
I think one of the best things about mock trial is kind of just being thrown out and in deep water and trying to land on your feet. I think this year we did a different approach from the year prior, which was not have everyone necessarily speak during the segments. I think while it's kind of a double-edged sword because we want to bring in as many people, I think it's also maybe even better if we were to have everyone speak regardless. Because it's really what it's about, I think, is the whole program is meant to have you see what you can do with sort of ridiculous prompts and situations and see how you balance it all. So I think the best way to do that is by pushing people to do exactly that and speak up. I think that's my takeaway.
It's a fair point. Fair point. Anybody else?
I would say, well, since this is my first year doing it, the only real familiarity I had with how it's done in the past is I listened to last year's podcast, and I can already say I think this year's was run better because of the time you had to prep in before. But I will say I think if we do keep it that you can participate and you don't have to speak, which again I do think that's fair. You shouldn't disclude people because they don't want to speak up. But I do think maybe a clearer point system should be awarded if you're not going to speak. I don't know if it's necessarily fair that if someone on your team didn't participate in the prep that they should be awarded as much in an overall team aspect. I don't know. And I don't mean it to be more of a competitive thing. I just think in terms of outlining who gets more points.
And to Addison and Brianna, Alexa still loves you, even though she thinks this one was better this year.
Sorry, guys.
I was about to go run over there and tell him.
I'll admit it to them after this.
All right. Cory, what's your thought?
So I was making a transcript joke earlier, but I was only half kidding.
Okay.
I think it's pretty helpful to watch back what you've done. And so, if you say you've never actually taken someone's testimony before, you kind of black out. You're in the moment. You don't really remember when you go back to think about it too much, or at least not in great detail. For me, I can say that I probably remember more of other people's testimony because I'm an observer rather than a participant. So I think if there was some way to record, not necessarily get a transcript, but maybe just record the testimony that's being taken, just so that the participants can watch it back, take some notes, maybe ask other people to view it and give them some notes. It definitely would help get better. I remember doing this a while ago in law school. For some reason, I had to do a pitch. And
for some reason,
had to do a pitch, but it had to be recorded, and we had to do 3 versions of it. And I remember by the 3rd time, I had it where I wanted it because I was able to go back, critique myself, and then go in and try to execute again. So I think that would also prompt more people to speak up if they can see something they want to work on, and then know, okay, next time we go in, I'm going to take this approach, or I'm going to ask questions this way. Because we did have a decent amount of, oral presentation that can be worked on, and it's easier if you can go back and see what you just did. That would be my
All right.
my assistance.
I think this was a great recording, Connor. Thanks for your help, this year as well. But for Cory Benavides, Tomer Lehr, Alexa Cintron, and last year's champion, Connor Wetherington, my name is Christian Cison. Reminding you, welcome you. It's like so many podcasts. I'm reminding you guys to defend from day one.